Thank you very much indeed, Professor Chris and colleagues. I'm going to take a very liberal view today, and liberal view with the time allotted to me. I've prepared a slide presentation. It's going to be available to you from the organisers, I think in early course. I'm only going to hop in and out of it, and I'm going to just touch on a number of topics, because I think the organisers, and Chris in particular, is anxious to have an interactive discussion, and I'm going to try to facilitate that a little bit as well. So, like the previous speakers, I just fastened on a few topics, and I've hopped around the new directive. I would add a word of caution, incidentally, that the directive will be in its authoritative version, or the directives, 3 of them will be in their authoritative version when published in the official journal. I've been working in meetings and travelling all yesterday and last night. And as of then, my last check, it hadn't appeared in the official journal just yet. So there will be some renumbering, there will be some tightening of language. It's with the jurist linguists for that purpose. It's something we're not used to quite in our conventional parliamentary system in these islands, but tightening up of the language, we're not quite sure what it will entail. So beware, if there are references to article number something here, it may have changed in just a few weeks when the authoritative version becomes available. And there have been various drafts floating around. There was the compromise presidency draft filed last June, July, and then it went through a few more iterations again, and then lo and behold, there was a sort of a doubled up set of amendments plugged into a text put before the Council of Ministers on the 11th of February, and articles which have been maybe XA or XB or XC will now get into a proper numbering sequence and so forth. So that process isn't quite finished. So just a little word of warning on that. So it's both exciting and it's also a cause for caution. Because some of the little glitches on the text may actually be ironed out when we see them. So the first point I'm going to mention is access to information. There are, of course, specific provisions in the existing law where information has to be conveyed to interested parties, for example, in the standstill letter, or where there's an elimination or so forth. There is a right of, under the directives, to inquire as to information. But there have been some significant problems, and in the context of simplification, codification, and all of the other emotion, trauma that Grace has so eloquently described, to do with consternation and so forth. It's just a little bit worrying that some of these are not yet fully ironed out. So I'll call attention to them, I'll pose some questions, and then I'll skip on, having whetted your appetite just a little bit. We have in particular a difficulty in the courts, in that in these islands in particular, that is to say England and Wales, Scotland, Northern Ireland, and Ireland, the Republic, there's a reluctance, a traditional reluctance in litigation to allow a litigant to take out what we term the fishing rod and go on a fishing expedition looking for information. And yet, and confronted with very short limitation periods, that is to say the period of time between becoming aware or deemed to become aware of a wrong and the point at which litigation proceedings must be instituted or the right to do so lost, it's a very tight time limit now. Under the Remedies Directive and Regulations as transposed, it's usually 30 days where people are on notice in these islands. So it's very tight. So people become aware, a business becomes aware of certain facts or certain information. What does it do? It may not have enough to justify what in England and Wales and in Ireland is a very expensive, in Northern Ireland is a very expensive litigation procedure. It's very costly. Unlike, for instance, in Denmark, where there's a readily available, more informal procedure at local level. And what do? Do they institute proceedings? Do they allow the opportunity to do so to go by? How else can they gain access to information? And there are, of course, Freedom of Information Acts. The Freedom of Information Act in England and Wales. There's a Freedom of Information Act in Ireland. And there are other measures around the place as well. But the traditional view, notwithstanding all of that, has been that where access to information under the Freedom of Information Act, or for example under the Aarhus Convention, access to information on the environment regulations, springing again from Denmark, great. They take time and they're limited, and there are quite significant defensive grounds available to usually the public body that holds the information. Can of course be held by an agent or whatever. And it just isn't quick enough, even if it's going to be forthcoming at all, to allow a decision to be made whether to launch proceedings or not. That problem isn't really dealt with yet. There is, of course, a reiteration of the confidential status of tenders. That's something that has been relatively little examined in the courts in this part of the world. There is the Veolia and Nottinghamshire County Council litigation, which I put up on the slide there, which really springs from a statute in England and Wales governing the National Audit Office, a bit like the old Controller and Auditor General as it used to be, and which allowed a ratepayer or a resident of, I think it was Nottinghamshire, to certain information, as he thought, in relation to the contracts pertaining to a waste facility. The High Court considered it very carefully in the context of the national legislation and gave access, or ordered access to quite sensitive, as it were, commercial information. It was appealed into the Court of Appeal, in which the Varick judgment of the European Court was invoked, hadn't been argued apparently in the High Court. And Varick essentially says, yes, there are rights of access to information, but there's also a general right to the confidentiality of a tender. And in essence, it said, there has to be a weighing of the respective rights of the parties, of the bidders on the one hand and the information seeker on the other hand. And the Court of Appeal applied that in the Veolia case. Even long after the procurement process had closed, it said that there was a significant interest in the bidder, now the contractor, in retaining the confidentiality of its information. And then there's been a series of cases on bidders seeking to gain access in the course of litigation to certain information. And the traditional rule was, don't allow the fishing expedition, I beg your pardon. But lo and behold, Miss Justice Coulson in the Roach case in England and Wales last year adopted a more modern statement of the law, which overrides some of the older decisions, and specifically in that he acknowledged the difficulty in a public procurement context of the shortness of the time limits and the scarcity of information, if you like, the imbalance in information terms as between a requester of information on the one hand and the body that holds it on the other hand. And it appears to override some of the older caution. Specifically in Northern Ireland, which again is not binding, decisions of which are not binding in England and Wales, but there would obviously be a very considerable persuasive authority, the same substantial common law, as it were, and ultimately under the UK Supreme Court. In the Scots Electrical case, as recently as 2012, the High Court in Northern Ireland applied the older test and denied the fishing expedition, as it were. But Roach has been applied very recently, within the last few weeks, in that case that I've put in the middle of that slide, Sisk and Son. But it's still a complication. It's still not fully simplified. It may not be capable of ultimate simplification, but it's at least a significant uncertainty, as it were, from the perspective of the citizenry, natural and corporate. So I'm not going to go into other aspects of information access, but suffice to say that there are still challenges there. Past performance, again, I'm not going to go into all of the gory details of that, but it's been a long-standing bane with public bodies. What do they do with people who are applying for contracts, candidates typically seeking to qualify, and when it's known that they have a less than glorious past record? Now, one aspect of past performance, which is the citation of the experience of relevant personnel, is very largely overcome by the terms of the new directive, Article 66.2, I think it's now actually renumbered again, but which essentially says that the bid team, where it's relevant for purposes of an award criterion, may advert to its capabilities, and that's legitimate for inclusion. But I think that will probably kill off the worst of the confusion that sprang from the Lianakis decision of a number of years ago. But there are other aspects of past performance, really, which refer to the exclusion grounds, and where I'm going to spare you all of the details, but suffice to say that there are two main relevant exclusion grounds, where first one is where the contracting authority has reason to conclude that the economic operators enter agreements that other economic operators have already dealt with the distortion of competition. TOTUS has dealt with that already, and where in Article 55, as it was, this is the grave professional misconduct one, but which is now linked to, and you see on the bottom of that slide, professional misconduct which renders its integrity questionable. Now that may be, I would have thought, rather a difficult thing for an awarding authority to establish in a way that's A, fair to the candidates or bidders, and B, is satisfactory from the perspective of the contracting authority that is obliged to apply the law and to eliminate where it ought to eliminate. It is admittedly discretionary. It may exclude in the directive, but if the contract terms include the possibility of exclusion on that basis, that may be but the contracting authority, facing really quite considerable decisions, no more than the abnormally low tenders, and incidentally abnormally low tenders are not even defined, and perhaps rightly so. So those complications will still remain. And then there's the other element then, is this is the persistent offender, as it were, where it's now stated one of the discretionary exclusionary grounds, which can become mandatory when put into the tender documentation or where required by a member state to be made so. It's where a supplier has shown significant or persistent, it doesn't even say and, it's significant or persistent deficiencies in the performance of a substantive procurement or a substantive requirement, as it were, under a prior public contract, not even necessarily with the same public authority. And what is, incidentally, a substantive requirement, and what is significant or persistent deficiencies, and is, poor performance on one prior contract sufficient? Those things are not necessarily simplified. Yes, there's perhaps flexibility, but there's quite a lot of danger inherent in it as well. So I'm going to skip on. The rest of it you'll be able to read in the slide pack when it becomes available to you. I'll just mention a few little thoughts. Graith has very helpfully covered much of TECAL and the public provisions. I'm just going to go on past that, though, because while there is a codification, as it's termed, of the in-house rule, and very helpfully so in as far as it goes in the directive, but there are still little lacunae in it and little pitfalls in it. But what I call the first cousin of the in-house exception, which is TECAL, is the Hamburg, the cooperative bidding. There's no attempt made to codify that at all. The Hamburg waste case, you may recall, was a decision in 2009 by the European Court where the Commission had instituted proceedings against Germany in respect of activity by the city of Hamburg, which went to the market very properly and procured the construction and operation of a waste facility. After that, or separate from that, the city of Hamburg, with a number of neighbouring local authorities, entered into arrangements for the supply of waste between each other to supply the plant. Just local district councils or whatever. And that was challenged on foot of a complaint. And both the Commission and the Advocate General said, well, this is not TECAL, because neither Hamburg controls the neighbouring districts, nor do the neighbouring districts control Hamburg. Therefore, the control test inherent in TECAL is absent. So that has evolved. And you'll see there what the court said in the Hamburg case, that in essence, where the cooperation is governed solely by considerations and requirements relating to the pursuit of objectives for the public interest, effectively statutory powers or the equivalent, and principle of equal treatment is observed, then that procurement can take place. Now again, I'll spare you the gory details, you can go through the slides yourselves, but there have been a number of case law decisions which have developed that, and they appear to say, for example, that the public duty must be shared by the two cooperating bodies, and that it can't just be, for example, springing from the Lecce decision in Italy, where a university collaborated with another public body to check out the seismic vulnerability of hospitals and other health facilities. The court has also said that even if there's apparently no profit or no cost, as was stated in the Hamburg case, and that was a finding of fact by the National Court. And what is that? Does it mean that if there's a gate fee, that it's a gate fee that has no profit component whatever in it? not clear. Not clear also what are the other no-cost elements. It's, the subsequent decisions, Echo Nord, for instance, say that if there's pecuniary benefit, even if there's no profit, well then that perhaps is something that brings it back within the general control of the procurement directives and outside the Hamburg exception. So there's codification, there's simplification, but there are ongoing developments. I also worry just a little bit that where, as a lawyer, where the court has built case by case on the facts as presented, that if there's perhaps what might be read as a prescriptive legislative provision, it may stifle a little bit the capacity for judicial development, which has its own merits as well. So it's a balancing or a countervailing factor. So I'll not attempt to go through all the individual slides, but I hope that that will help a little bit towards inspiring the discussion and of the topics which Professor Chris and the organisers have very helpfully put before us here today. Thank you very much indeed.